Welcome to my YouTube channel. Hello everyone, I wish you have a great day. I welcome you to my YouTube channel Saraswati. I am going to explain the basic introduction of contract law in this video. I hope you would love this. So the topics to be covered in this video are: first, meaning of contract law; second, history of contract law; third, topics under contract law. First, meaning of contract law. So, contract law is the branch of civil law that governs legally binding agreements between two or more parties. It outlines the rules for creating, interpreting, and enforcing agreements and provides legal remedies like compensation if a promise is broken. In simple words, contract law is the statutory legislation which regulates the agreements made between two or more parties, and if any person violates any provisions mentioned in legislation will be responsible for providing compensation. Simply, it can be understood that contract law protects the promises made by two parties made under an agreement. Important terms of contract law: contract, second, law; third, civil law; fourth, agreement; fifth, parties; sixth, rules; and seven is compensation. What is a contract? General meaning: the word contract is derived from the Latin term contractus, means to draw together or to bring together. Definition by various jurists. First is settlement, an agreement creating and defining obligations between the parties. Prologue: every agreement and promise enforceable by law is a contract. By Indian Contract Act 1872, the Section 2, subsection H provides definition of contract as an agreement enforceable by law. What is law? Law is a set of rules created and enforced by a governing authority to regulate behavior, maintain order, and protect individual rights. It ensures fairness and provides consequences if the rules are broken. There are various types of law, such as property law, criminal law, civil law, contract law, etc. What is civil law? Civil law is a branch of law that deals with disputes between private parties, individuals, businesses, or institutions rather than with criminal offenses. Its primary goal is to resolve non criminal conflicts, enforce private rights and obligations, and provide remedies like financial compensation. This law does not include punishments like imprisonment. Example: law of torts, contract law, property law, consumer law. What is an agreement? An agreement is a broad term which means a mutual understanding of assent between two or more parties regarding their rights and obligations. It can be formal or informal, written or verbal, or implied through conduct. Two important essentials: offer, acceptance. What do you mean by parties? Parties are the individuals or organizations or entities or corporations that enter into a mutual agreement. Two types. First, promisor. The person who makes a promise to another is known as promisor. Second, promisee. The person who accepts the promise is known as promisee. What do you mean by rules? Rules are the instructions or the guidelines that tells what is allowed to do and what not to do. They are designed to keep things fair, safe, and organized. Example: to stop during red light and to go during green light. What is compensation? In simple language, compensation is the amount of money paid by one to another. In law, compensation is a legal remedy or financial award given to an individual or entity to make up for loss, injury, or infringement of rights. Its purpose is to recover the loss. History of contract law. First, ancient and medieval period. Second, British era and English common law. Third, enactment of Indian Contract Act 1872. Fourth, post-independence and modern era. So first is ancient and medieval period. There was no uniform contract law across India. Transactions were governed by diverse personal laws, including Hindu and Islamic doctrines. British era and English common law. British East India Company rules in the territory of India and developed many charters and Third Law Commission. To establish a legal system across India, Britishers drafted a comprehensive contract code based on the principles of English common law. Enactment of Indian Contract Act 1872. First, passed by the British government on April 25, 1872. Second, it came into force on September 1, 1872. It contains 266 sections. Now, post-independence and modern era. During modern era, some of the chapters of the Indian Contract Act 1872 are further established into separate acts, such as Sales of Goods Act 1930, Indian Partnership Act 1932. And then the last topic is Topics of Indian Contract Act 1872. First is communication, acceptance and revocation of proposals. Second, contracts, voidable contracts and void agreements. Third, contingent contracts. Fourth, performance of contracts. Fifth, certain relations by contracts. Consequences of breach of contracts, sale of goods, indemnity and guarantee. And the last is bailment, agency and partnership. Thank you so much. If you like my video, please do like and subscribe to my channel.